Let me go to Nolan Coinas from Texas. Hey, Nolan.
Yes, sir. I heard that Comrade Obama was talking the other. I had heard that Comrade Obama
Yes.
was talking the other day about raising the inheritance tax to 45%.
Yes.
And what I was wondering is, I have a family farm that I'm going to leave to my kids and grandkids. And if I put them on as right of survivorship, would I get out of that tax of them having to pay it?
Here's what you need to do. You need to give them the ownership of it now. And how you do that, Nolan, is you need to try to put that into a trust, a living trust, a family trust. And you and your spouse are going to be trustees of the trust. Your children are going to be co-trustees of the trust. Okay? So the trust now, this asset, this farm is no longer owned by you and your wife. You still have full control, of course, of what goes on, but it's no longer owned by you. It's owned by your name, Nolan, and your wife, such and such, family trust, dated whatever. That's who owns it. The trust owns it. So, therefore, when you and your wife are both called home to be with the Lord, you might have something in that trust that is a triggering mechanism, it's called, that says, upon my death, I would like the trust dissolved. At that point, the trust would go to the ownership, the farm would go to the ownership of the co-trustees, of the other trustees of the trust. Now, nobody died. Nobody died in order for them to get it. That's the loophole. Nobody died. Now, your death was a triggering mechanism to disperse assets, but that's all it was. It could have been the death of your cat. It's irrelevant. But it's not because, it's not an inheritance. They didn't inherit it as a result of your death. The trust was just disbanded as a result of your death. So that would be the safest way to do that. And I know I have a lot of ranchers and farmers listening. If you have not done that, please do it. I know it's going to cost a little money. So, Nolan, it's going to cost you some money from a legal fee standpoint to establish the trust. Remember, when you do it, not that lawyers might not think like this. I owned a trust company for 22 years. I settled a whole lot of estates, probably a lot more than a lot of lawyers. Look, the thing is, your children can't be. They need to be trustees of the trust now, not successor trustees. I know what the law says about successor trustees, but they need to be trustees now, because I don't trust the government well enough to not change that rule either. So I would put it into the trust. Here's the problem. I don't know how big your farm is or your ranch, but I'll say this. One of the issues that this is a stumbling block for a lot of people, is that when you put it in the name of the trust, there's usually a transfer tax. That's something that's done on the local level by the state. So there's usually a transfer tax, and it's usually no more than 1% of the appraised tax, the tax appraised value of the property. So that's a stumbling block, because people say, I don't want to pay the tax. Well, it's 1%. Your chances are your children, if we maintain this ideology in Washington for any length of time, are going to lose it anyway, because they're going to have to sell at least half of it to get the tax money to keep the other half. So that's what you need to do.
I talked to my dad yesterday, and his ranch is a whole lot bigger than mine. And he's under the impression that it had to be into so many $1 million before it applied, before the inheritance tax applied. And I was telling him, I don't think so. I think they're going to nail everybody.
No. He's right about that, Nolan. He's right about that.
Oh, is he?
So, yeah. Oh, okay. So there's a threshold. So here's what happens. Every one of us right now have a tax a federal tax credit. And between you married, Nolan?
Yes, sir.
Okay, so between you and your wife, it's about $6 million. So if your assets don't total up if they total up to $5 million, you're okay. Now, here's the issue, though. You still have to have a will in such a way that preserves your spouse's tax credit for the estate. So I'm trying not. It's a little complicated, but so if you die, your tax credit dies too. It's gone. Okay. So now you thought you were protected, but now it's only your wife's tax credit because everything's going to go to her with no estate tax or anything like that too. Everything's going to just automatically be hers. And then there's so what's going to happen is when she dies, that federal tax credit now is cut in half because you're gone. It's only going to be half of it, and it might not qualify. But there's a way in the will to preserve and actually pass along your federal tax credit to your estate. So that now, when your wife is called home to be with the Lord, you get both of your tax credits, the estate does, in order to try to, preserve as much tax credit. So now, let's just say it's, $10 million by then. So if your ranch is worth $11 million, they would only have to pay tax on $1 million. Okay?
Yes, sir.
All right. So hopefully...
Thank you very much for what you... Thanks a lot for what you do, and God bless you for your information.
Thank you, Nolan. I appreciate that. And, I'm very, very passionate about that topic because I love farmers. They're the heartbeat of America and ranchers. And I get so concerned because I know that there are third generation farmers that are going to lose everything, which is so sad, that are going to lose the whole deal because they just didn't plan properly. Mitt Romney had it right. He said that the death tax should be illegal. There shouldn't be any inheritance tax. His first order of business, had he been president, was going to be to do away with it. That's the way it ought to be. But we've got a mentality in Washington that is all about tax revenues. It's not about anything else. Forget about a thriving economy. It's about tax revenues because tax revenues are going to allow them to continue to spend and gain more power and more social control. So that's what it's about.